Hi, I'm Brian Carney. For over 10 years, I was a prosecutor in the city of Boston. During my time there, I started the Interactive Multimedia Presentations Department, which still exists today. Upon leaving, I founded Win Interactive, and for the past 18 years, I've been helping prosecutors throughout the United States on high-profile criminal prosecutions present evidence using visualization technology, 3D animation, and interactive timelines. With my over 20 years experience in creating and presenting interactive timelines, we have developed Crime Lines, an interactive timeline tool for prosecutors. Timelines are easy to build, easy to present, and powerful. Prosecutors can now present complex evidence in a simple and organized way. With our 15 pre-designed templates, timelines can be colorful, clear, and professional without the need for a graphic designer or a trial consultant. All of your evidence, whether it's video, audio, documents, photographs, and diagrams, can be linked to any event. With Crime Lines groups and views, it's easy to create unique timelines for each witness using the same data set. Crime Lines is made by prosecutors for prosecutors. I'm proud to say that Crime Lines is now being used in over 25 states. Download your free copy or stop by our booth and learn how Crime Lines can help you achieve justice in your next trial.
I had a homicide case a couple years ago. One of the key pieces of evidence were text messages between the co-defendants, the victim, and other individuals that were kind of knew what was going on or what was happening. We got tens of thousands pages of data, but there was probably 30 or 40 text messages that were relevant to what we wanted to present. And we were able to do that in a very concise, easy to follow manner by putting them into a timeline. So it was easy to show the jury and allow the jury to follow the conversation on what was being said, who was being told what to do. It allows us to be very concise and direct with the jury. I presented my entire case in one day, which would have probably prior to Crime Lines would have taken 2 or 3 days in order to put that same evidence in. After this case, I did talk to some jurors, and they talked about the crime line and how easy it was to understand and follow what was happening and when it was happening and who was doing what, which makes the job as a prosecutor a lot easier. It makes your evidence a lot more credible. It allows the jurors to easily understand what the evidence is and what the evidence says.
One of the benefits of certainly NDAA and seeing how other prosecutors across the country present the visual trial is to understand that trials are visual and that jurors particularly understand things better when they can see it and that they're not just told about it. We're using technology in the courtroom. We're able to incorporate audio and video and graphic representations of certain aspects of a crime to be able to tell the story. Because in the end, a crime is an event that happened. There is a basic truth behind any crime. And I think one of the great things about bringing technology into the courtroom is the ability to tell the story in a clear, concise, and understandable manner. And I have seen it done both ways. I have seen it done with just the lawyer talking, I've seen it done with placards, and I've seen it done using the technology that's available today. And I can tell you, jurors appreciate being able to understand the story in the way that they're used to seeing stories told, visually, on a screen in front of them. The facts are still the same. The way those facts are being presented has evolved, and we're now fortunate to be able to bring that technology into the courtroom.
It seems to me that there are two basic important components to being a good visual advocate. One is knowing how to think visually. and the second is knowing what the tools can do for you. One without the other doesn't get you there. Thinking visually from the get-go helps you to organize the facts of your case and helps you to build a more effective theory of the case.
Because you've got to tell the story visually. If you can do it in a compelling way, then you can win the case.
Space and time. This isn't a physics lecture, but I think I can explain two of the more powerful ways in which visuals help in this way. Space. What visuals allow a lawyer to do is to communicate concepts, sometimes very complicated concepts, and especially relationships among concepts in terms of spatial relationships. And that's good because, after all, we, like much other animals, have been hardwired for millions of years to respond to spatial relationships, whereas the skills necessary to process conceptual relationships are rather newer and more difficult, and not everybody has them, and they don't come easily. So if you can convert a difficult conceptual relationship into a relatively simple spatial relationship, the viewer can get it like this.
One of the most important technologies that a law firm can use if you're a trial lawyer is you need to have animation, you need to have visual graphics.
Another very common form of visual display that in a way combines both space and time is the animated reconstruction of an accident or a crime merely from verbal description. It may be very difficult for the decision maker, whoever it is, to understand the relative position of shooter and victim, or the relative position of two cars, especially if those things are changing over time, especially if whatever forensic evidence happens to exist in the terms of photos or videos taken at the scene after it's all over, leave what happened before and the specifics of the spatial relationships unclear. And animation can make that clear as long as it's sufficiently grounded in the data. It can make both the spatial relationships among the crucial actors and events and also their temporal sequence much clearer than it would be otherwise. Time. There are a couple of ways in which visuals can present complicated events that unfold over time in a way that makes those events easy to absorb, easy to understand by the audience. First and simplest is simply to present a timeline, right? Rather than simply presenting a sequence of witnesses, asking what happened when, expecting the decision maker to keep in mind a possibly very complicated series of transactions involving multiple people over multiple time scales, show it. Put a timeline on the screen and set at each juncture links to the particular events, which can then be expanded at any desired level of detail, but most importantly will allow the decision maker to see at once the whole time scale of the crucial events.
Attention all squad. Attention all squad.
911.
Hello. He's ready off building again.
Okay.
If you are able to think visually and make the visuals, or at least understand how the visuals you would want to use could be made by you or by somebody more expert in it, it helps you throughout the course of the case, from case preparation to the conduct of the case and every phase of the conduct of the case. First of all, thinking visually from the get-go helps you to organize the facts of your case and helps you to build a more effective theory of the case. If you imagine, how would I present this if it were a little documentary? How would I present it if it were a 15-second ad on TV? Now, I'm not saying that the demeanor of the final product should be like a television ad, but you can get some lessons from advertising in how to present a message in audiovisual form in a very compact and effective way. And if you can formulate, if you can be thinking about what would that key message be, what would the crux of the case be, while developing all the evidentiary support for that, I think you can develop a more effective theory of the case and marshal and organize your evidence in a more effective way. So that's something that a lawyer should be thinking about from the beginning of the case. And then at every stage of the case, visual presentation can help the lawyer communicate his or her messages more effectively. I'm a firm believer in honesty in the use of visuals in court. And one of the things that includes is being transparent about the source of any evidentiary visuals, being prepared to document, for instance, any alterations in the creation of the visual, being prepared, if necessary, to have the maker of the visual authenticate the photo or the diagram or the video or what have you. I also believe that, consistent with the lawyer's other professional responsibilities, that each side should exchange its evidentiary visuals before trial so that the other side has an opportunity to examine them. It's a different matter when it comes to visuals used on cross and visuals used in argument. There's no professional obligation to disclose one's strategy to the other side. When people get information in pictorial form, they tend to have more confidence that they know what they need to know to make whatever decision they're asked to make, right? Seeing information in pictorial form enhances their confidence that they know what they need to know. And this can be the case whether that visual information is a surveillance video or an animation or an infographic, right? And so that's also obviously very helpful to lawyers who are trying to persuade an audience that their side is in the right. Visuals communicate information in ways that words don't, and communicate them more effectively than words do. For instance, people are able to absorb visual information much more quickly than they can verbal information, and generally speaking, much more easily. People can get the gist of a picture, or the sense of what the picture means, in as little as a third of a second. Now compare that to how long it would take to hear or read a verbal description of what's in the picture. And you can see that getting the information in an instant can be a great advantage when you're presenting lots of information in the course of a mediation, arbitration, or trial. Moreover, people absorb pictorial information more easily than they do verbal information. And when people have a sense of absorbing information easily, a phenomenon known as processing fluency kicks in. And basically that's a psychological principle that says the easier it is to take in information, the more you like it, and the more likely you are to believe that that information is true. So visuals are much more amenable to being processed fluently, and therefore when people take that information in, they're likelier to think that the information that they're getting is true. The use of technology in the courtroom can be persuasive for a couple of reasons. One, for the substantive reasons I've already been discussing, because it presents visuals and audio visuals more compactly, more powerfully, more effectively, but also because the lawyer who is good at it, the lawyer who is good at presenting visuals smoothly in the courtroom, when a witness comes to a certain point in the testimony and the relevant picture goes up on the screen, for instance, that facility with the presentation of visuals in the courtroom will make the jury think that the lawyer is more competent, better prepared, more persuasive. The flip side of that is that a lawyer who is not adept with the technology, or who doesn't bring with him or her to court someone who is and who flubs up in court, that can have a boomerang effect. So you can not just lose the potential advantage, but also have it held against you if the tech doesn't work. So the lawyer needs to be prepared in every respect, which means checking out the venue beforehand, making sure the equipment works, bringing backup, and wherever possible, having somebody on hand who's knowledgeable and a professional who can actually run the equipment so that it works smoothly in the courtroom. Even when lawyers recognize that a visual display would be useful, there's the problem that lawyers don't know what they don't know. And they think that they can do it well enough on their own. In fact, in my visual persuasion class, we happened to have the last class of the semester recently, and one of our students told us of having this experience at her last job, where the prosecutor put on a PowerPoint closing argument, and she said, it was awful. It was filled with all of these, the fancy wipes and fade-ins and dissolves, but they didn't serve any purpose. They're just eye candy, made for a terrible presentation. Now, why the lawyer thought that that was the way to go, I don't know, but clearly this lawyer didn't know what he or she didn't know about effective presentation. You really want somebody who has had some training, had some experience, and has some skills in putting together visual presentations to be able to realize the lawyer's vision more effectively. Videos seem like such compelling evidence, and again, like many other sorts of visuals, but perhaps especially for videos, when people see video, they think they've gotten the story. They think they understand what's going on. What people don't tend to realize is both the extent to which their own prior attitudes, their own biases, shape what they literally see in the video, as well as what they construe from it. And they also don't appreciate how all of the formal aspects of the video, the size, the framing, the point of view, the angle, the sound, if there's any, also shape what they are taking from the video.
Plymouth is a large community. It's about 103 square miles. It's probably about 60,000 residents during the winter, and it swells over 100 during the summertime. A lot of activities, a lot of bars, a lot of drug activity. It's a very busy area. My name is Adam Larsen. I was a police officer in Plymouth, Massachusetts for 11 years up until the incident. I was up for promotion for the position of sergeant, and I was an Air Force veteran. I was a field training officer, and I was on the mounted unit. I was called to a shopping center for a report of a highly intoxicated male and female, kind of a domestic or verbal argument. Upon my arrival, we dealt with the situation. We determined I was going to place them both under custody. Once they got back to the station, they were booked. Usually the booking process would take maybe 20, maybe 30 minutes. This probably went on for over 40, 45 minutes of length just because she was so intoxicated. She wasn't cooperating, didn't want to go in the cell. It was just more time than it usually takes, but she was so intoxicated and she was so hard to deal with. So she was so intoxicated that when she fell back, she fell into the bed, striking the back of her head. She went unconscious at that time, and I was standing next to a lieutenant at the time, and we both rendered first aid, and we got her to the hospital for her injuries. Well, initially I completed my report. The lieutenant that was with me contacted the operations captain, who said he was in contact with the chief, let him know the situation. They said there was nothing to worry about. It sounds like it was a slip and fall. Complete your report as normal. Probably about 3 days later, Monday morning, the chief and the captain reviewed the videos, and they became extremely concerned about what had happened. After the second interview, I was on admin leave, and the first time I remember going home on admin leave and really sitting at home by myself after going into work and then being told, "You're out of work right now, don't come back." The charges were 2 felonies for a police officer were just, it was scary. I was really scared to death. I didn't know what to do. I didn't know what was going to happen for the rest of my life. I really was like, this is it for me. What do I do? How do I start over at my age with a young family?
Well, the video itself was horrible. I mean, it showed this woman, she smashed her head back, and it just almost gives you like a physical reaction inside that makes you feel bad. But by the same token, my client insisted he didn't do it. My name is Kenny Anderson. I've been a lawyer for 29 years. I started out doing insurance defense for 1.5 years. I was completely miserable. Went into the Stafford County District Attorney's office, where I worked for almost 6 years. I did appeals for 1.5 years, was a prosecutor in the Boston Municipal Court for 1 year, and then in Superior Court for about 3 years. I left there, I went to a firm that does a fair amount of different types of work, a lot of police misconduct type allegations, represent a number of police unions, some correction officer unions, teachers union, did some insurance defense, some personal injury. So it's a broad mix of civil and criminal work, both on the defense and on the kind of the prosecuting the plaintiff's cases. I received this case from a lawyer who'd been handling the labor component of it, and it had a video of an intoxicated female prisoner walking into a cell and just falling down like a ton of bricks backwards, very graphically striking her head on a cement bench. And as she starts to fall, you see a hand come into the screen and a foot come into the screen. My client was adamant that his hand was locked out and that he never pushed this woman and that she walked into his hand and fell. But because all you could really see was the body coming back in and then the hand coming in, I really struggled with how to portray this to the jury and how to make my argument that my client didn't push this woman with something where on a superficial level, it certainly looked like he pushed her. The lawyer who had been handling this had gone out to some conference, I believe it was in Las Vegas, and had asked some people that do, the same type of work, who she should get to help review the video. And she came up with somebody in Northern California who basically took still photos and sketched little loops about how the person was coming in centripetal force. But it really wasn't helpful. It wasn't anything that was going to carry the day. And this person was in California. Just the expense of engaging him, flying him out to Massachusetts, putting him up in a hotel, having him testify at a trial with the product that I thought was really subpar. It just didn't make sense to me. And at that point, I reached out to Win Interactive.
Ken gave me a call and asked me to look at some surveillance video footage. What appeared to be a woman being pushed into a jail cell, slamming her head against a cement bench. I went over to his office and looked at the video footage, and it did not look good. It looked very bad for the police officer. It looked like the woman was being pushed into the jail cell.
All of a sudden, Brian said, "You know something? I can't tell based on this. We need to do some testing. But that hand could be coming down. But we need to do more digging and get some better information before we can make that decision."
As I looked at it more and more, I realized, well, there's a couple things in the video that don't seem right. They seemed off. Well, one was that her body was not falling in the way I expect the body to fall if it was being pushed. And the other was that the hand did not appear to be moving forward. It actually appeared to be moving down. I told Ken that we would need to go to the Plymouth police station to test out these theories.
It was a huge relief to have someone else believe me after watching the video and really believe me. And I felt like this was an expert that knows what he's doing. He's an attorney, and he looked at this and said, there's more to the story than just what we're seeing.
After that first meeting, we kind of had kind of a roadmap of what we're going to try to do. We're going to try to determine, is this hand going forward or is it going down? And is that the mechanics of a fall or is that the mechanics of a push?
The first time we went into that station, and the first time I'd been in that station since the last time they basically took all my stuff and I was fired and they took all my gear back. So going back in there, it was very uneasy. I kind of wanted my attorney right by my side. I was very nervous being in there for the first time, seeing some faces I haven't seen in a while. And even the captain that, really prosecuted me and really jammed me up with his investigation was there, and it was an uneasy and unpleasant feeling. But then I go in and see I have a team of guys that are like on my side working for me, and I was so impressed. And I was like, why didn't the department or the town do this to protect me? Why am I having to do this to protect myself? But I was amazed and overwhelmed with the tape measures and the checkerboard and the GoPro cameras, and everybody had a job and everybody knew what they were doing and everybody was ready to do it.
We came up with a game plan to measure the jail cell using two different methods. One was the traditional method of just measuring using traditional tools, and the other was to use a checkerboard system of black and white squares to be able to measure the height of the objects in the jail cell. These methods allowed us to measure the dimensions of the cell and the size and positions of the objects inside the security video footage.
There was a GoPro camera that was looking at the door where my client's hand had come. There was a GoPro camera up on the ceiling looking directly down. There was a GoPro camera looking from the side showing my client's hand, and there was another GoPro camera showing his feet. And all these cameras were synchronized.
By setting up the GoPro cameras outside the cell as well as inside the cell, we were able to see things that the surveillance camera footage could not pick up, which was what position was Officer Larsen's body in during certain movements. And we were going to try to replicate the movements that existed on the original surveillance video. We would then be able to see what Officer Larsen's body was actually doing outside the cell.
I was extremely pleased and proud of what the WIN team was doing there, but I think what I enjoyed the most was seeing kind of the shock and awe on the police captain's face as he came down and said, "This is fine, take as long as you want, do what you're doing." But he had no idea what we were doing. I think he thought we were going to come, measure some things, take some pictures, be gone in 10 minutes. And he didn't understand that this was going to be, we were there for a couple hours and we were going to get to the bottom of this. And that's exactly what happened. And I left there that day knowing that we had disproved their theory of the case.
As we left Plymouth Police Station, I was excited, and I spoke to Ken and Officer Larsen and told them that I believed that we now had evidence that the hand was moving downward, not thrusting forward. First thing the WIN team did was to analyze the surveillance video to determine what the hand was doing. We synchronized the GoPro cameras with the surveillance video camera from the test in order to determine what the hand was actually doing versus what it appeared to be doing in the surveillance video camera footage. We then took the hand drop test and synchronized it with the original security footage. We determined that both hands were moving in a substantially similar manner and in the same area of the screen. The second thing the WIN team did was to build a 3D model to determine the position of the body during the fall. We provided the 3D artist with measurements, photographs, and the surveillance video footage with the checkerboard system overlaid on top of that. This allowed the 3D artist to understand the body position and height during the fall. We were able to recreate the body movement of the woman by placing the foot positions of the 3D model over the foot positions of the woman in the surveillance video. With the 3D model, we were now able to look at the body positions at any angle during any point of the fall. This led us to viewing the fall from the side, allowing us to see that her rear end was over the back of her feet, causing her to fall. During our video analysis, we found something that we did not expect to find. We found a shadow on the wall that was moving down in our video surveillance test, and we found that exact same shadow on the original surveillance video footage. This corroborated our belief that the arm was moving down, not forward.
Everything was so detailed. The investigation that had been done by the police department, there were no measurements taken. The captain didn't know how many frames per second. And this was so precise, and it was just done in an airtight way that it was a presentation that nobody could really dispute.
I believe WIN Interactive was able to really show the truth and what had actually happened, not what the police captain at the time assumed he thought he saw on the video. When WIN Interactive was able to break it down and show what really happened and not just an assumption.
In my opening statement, I used this quotation from John Adams as he was defending the British soldiers in the Boston Massacre trial, that facts are stubborn things. And I said, these are facts that you're going to hear. And there were the facts that Brian and his team helped me dig up. And these were things, once you watched the presentation they had, it wasn't smoke and mirrors. These were facts. And those facts, again, could not be moved. They were stubborn things.
I felt my attorney, Ken Anderson, was a strong attorney, and Brian Carney and WIN Interactive put his case over the top. I almost felt that I was going to win the first day we walked into that courtroom, because I know the team that I had behind me, I was in very good hands. And what WIN Interactive provided to my attorney really locked in what had happened and was able to clearly show that I was wrongfully accused.
So as I testified in front of the jury, I was actually noticing the jury's reaction to my testimony. They seemed a bit disinterested at the beginning, and then as time went on, they seemed to be riveted to the explanation and the analysis that we had done with the 3D models and the video surveillance shadow analysis.
This video and the testimony that came out was, in my view, so compelling and so airtight that the prosecutor was really left in a situation where he would just throw in mud, during cross-examination, hoping to get something because he couldn't really contest the facts. So then he started to contest, Brian's qualifications, saying you're not an engineer, you're not a biologist, you're not a chemist, and it just almost got kind of comical. Like it was clear that this video presentation had won the day, and he just didn't want to lose.
I had the opportunity to speak to the jury foreperson after the trial, and I learned some interesting information, which was that they did not believe Captain Rogers by the end of his testimony. The cross-examination by Ken Anderson was extremely effective, and I believe that was directly connected to Ken's full understanding and thorough knowledge of his case because of our 3D analysis and the shadow analysis that we had done. The jury foreperson described our analysis as thorough, objective, scientific, and clear, as compared to the state's. The jury foreperson also told me that there was one holdout juror who actually changed his mind as a result of our presentation and my testimony.
After knowing what actually happened in that video, it was an interesting feeling, saying this isn't really what happened. You know, it looks like she's being shoved, but she wasn't. And even though on the superficial level it looks pretty obvious that she's being pushed, part of the argument at trial was that had they really cared to investigate, and after my client said that could be my hand going down, this is something that could have been solved very quickly by the police department. Had the investigator gone down to the office, called up on his cell phone, and had communication with somebody who was watching the live feed, he could have done what we did had he either been creative enough or smart enough and realized that, hey, it looks like a push, but it's really not.
It's definitely been a long haul, this whole process. Even from the first time that I met Brian Carney and Win Interactive to now, I feel like a totally different person with the respects that I've been proven innocent, clearly proven that I did nothing wrong. And it's a good feeling to be able to show my face in town now. I'm not hiding, I'm not staying out of the limelight, I'm actually going out to dinner in town, and I'm not afraid that people might think, oh, that's the bad guy.
When this came back as a not guilty verdict, as it should have, it was extreme relief for him and very gratifying for me, having been able to help him.
It's hard to describe how it feels to be able to help somebody like Officer Adam Larsen receive his career back. He was charged with a crime that made it with video that looked like he had committed the crime, and to be able to analyze the video and prove beyond a reasonable doubt that he was not guilty of that crime and help him receive his job back is an unbelievable experience. And then to receive photographs like I have from Adam Larsen, showing him in a police uniform with his children, happy that he's got his career back, is something that words really can't do justice to.
I would recommend Win Interactive to anybody because they were accessible, they were knowledgeable. They actually dug into this and found out what really happened. Because if it wasn't for Win Interactive, we would have had a very uphill battle facing a very compelling and ugly video. But they were there, they were professional, they saw things that nobody else saw in this video, and they had a very congenial approach in helping us work as a team together, deciding how to present this to the jury.
The lesson from this case is that video evidence is extremely powerful, both for good and for bad, and that video evidence, although it appears to speak for itself, does not speak for itself. So trial lawyers cannot rely on simply what they see in the four corners of the video screen, and really do need to become visually literate or hire somebody like Win Interactive who can help them analyze video so that justice is done.
Using visuals in cross-examination, sometimes one can anticipate well enough what the other side's witness, especially expert witness, is going to testify because you have prior disclosure about that, and the lawyer can prepare visuals to be used in challenging or taking apart the expert witness's testimony. Sometimes the expert witness on the other side may introduce a visual of his or her own, and then if the lawyer or the visual consultant whom the lawyer hires is adept enough, they can take that visual and deconstruct it on the fly during trial and then represent it either during cross or during the presentation of that lawyer's expert witness. And that can be a highly, highly effective technique because you're turning the other side's visuals against it. The power of visuals to create a strong first impression is crucial to the case, regardless of whether you are the proponent of those visuals or whether the pictures are being offered by the other side. When you're the proponent of the visuals, obviously being able to present the pictures yourself gives you a great advantage if you can present the pictures in a way that the jury will understand serves your theory of the case. There's a very well-known psychological principle, the confirmation bias. Once a person has a clear idea, clear opinion about something, the person will tend to interpret subsequent information in a way that's consistent with that initial impression. So that if you can create a strong impression by means of a visual at the beginning of the case, you can incline the jurors or the judge or whoever the decision maker is to take in subsequent information in a way that's consistent with that impression that's initially been formed. So it's very useful to create that powerful, easily absorbed, credible first impression using visuals. Now, what if it's the other guy that's presented the visuals? Well, you as the opponent, as the adversary, may well be in a position to take on those visuals either by challenging them if you have the knowledge and the vocabulary for addressing them, for deconstructing the visuals on the other side and undermining the decision maker's belief in them. Or you can create your own visuals to create a kind of visual counter story to the one initially presented. So it works on either side. It's important for both sides of the case to be able to create visuals that serve their purpose and also be in a position to take on the visuals that the other side is using.
I'm Bill Fitzpatrick. I'm the president of the National District Attorneys Association. I am the elected DA in Syracuse, New York, Onondaga County, a county of about 500,000 people located right in central New York. I was first elected in 1991. I've been re-elected 6 times, running for my 7th term right now. And I'm very honored to be the president of the National DAs Association, which is the voice of the 2,500 elected DAs and the 35,000 assistant DAs who work tirelessly for justice throughout the United States of America. I've been president of the NDAA for a little over a month. I succeeded my good friend Mike Moore from Beadle County, South Dakota. NDAA's responsibility primarily is to be the voice of America's prosecutor. It's constantly an effort on our part to make sure that the truth gets out about what prosecutors really do, about how they protect people, convict the guilty, exonerate the innocent, and never stop striving to make every single living place in America just a safer place to be, to raise a family, work, have a job, educate your children, and grow ever more into a productive life. I've been the DA in Syracuse since 1992. I was in private practice for 5 years before that, and for 10 years before that, I was the chief homicide prosecutor in my county. I love trying murder cases. I've been elected for 24 years. I'm running for re-election this year, and I still love to try murder cases. If you've done it, I don't have to explain it to you. You know how important that is. And the honor of my lifetime is to be president of the National DAs Association, to speak for America's 2,500 elected prosecutors throughout the United States of America. We prosecute 95% of the crime in America. Well, a number of years ago, there was a physician's wife in my county who died at her home, and my medical examiner, along with the local police department, went to the scene, and after about a 45-minute review of the scene, the medical examiner determined that the cause of death was consistent with an accidental fall in the shower. I had an assistant DA who was at the scene. She was suspicious, the cops were suspicious, but nevertheless we had this ruling that the fall was accidental, so the only thing we really could do at that point was gather some cursory pieces of evidence and take some photographs. Several weeks later, a former medical examiner contacted me and suggested to me that there might be more to the story, namely that it might have been a homicide. And at that point, I asked her if she would be willing to review the file. She did so, and I agreed with her assessment that it, in all likelihood, was a homicide, and we began a very, very intensive, over 2-year investigation into the cause and manner of this poor woman's death, and eventually resulted in the indictment of her husband, a prominent OBGYN in my area, delivered, thousands and thousands of babies, and he was indicted for the crime of murder in the second degree, which in New York is an intentional murder. I mean, the obvious challenge with the case was that you have a respected medical examiner who testifies for me 99.9% of the time, calling this an accidental slip and fall in the shower. So what we did was we consulted a number of outside forensic experts. We had blood spatter experts look at the scene. We had forensic pathologists look at the injuries to Leslie. And we also gave the defendant an opportunity, then suspect, to tell his side of the story, which he availed himself of. He allowed himself to be interviewed by me with his counsel present. And at the end of the day, every single person that examined the case concluded that it was in fact a homicide. How do I now present this to a jury without the obvious reasonable doubt of, hey, wait a minute, the local medical examiner said it was an accidental slip and fall in the shower? I realized very early on that this had to be a presentation not just of testimony, but of visually reenacting the crime scene. Let's take a look at the house itself. Where were people when they claimed they saw certain things? Where were people when they said things that were recorded by 9/11? What did the blood spatter actually look like? Where did it come from, and where did it wind up? Let me do a 3D recreation of the scene. So without going back to the crime scene, which was impossible because of the amount of time that had lapsed, let me put the jury in virtual terms inside the crime scene. See what the defendant claims he saw, see what the victim saw, see what the daughter, who was the only other witness who was present at the time of the homicide, what did she see? When did she make these calls to 911? When she said she saw this, where was she standing? That, is something that I couldn't have done when I first started trying murder cases. I tried my first murder case when I was 25 back in 1978. I could not have done then what I tried to do in this particular case. Back then, you put in photographs of the crime scene, you handed them to the jury, the jurors looked at them, one by one. It was a tedious, sometimes time-consuming process. There was no such thing as a PowerPoint. There was no such thing as a 3D recreation. There was no such thing as animations. So all of these things, which are relatively new to me, but is what Win actually does for a business, were things that I thought, based on my conversations with them, had to be involved in this case. Yeah, if you can picture in your mind a woman, my victim, Leslie, lying in bed. She's on, if you were standing at the base of the bed, she's on the right side of the bed. To her left is her nightstand. She has things on the nightstand like you might imagine: a clock, radio, a phone, some other personal items, some tissues, some family photographs. But also right there were 2 Poland Spring water bottles. And if you, again, picture in your mind, when she was attended to by the EMTs, she's now out of the bed. She, according to her husband, has suffered a serious fall in the shower. He has brought her 60 feet back to the bedroom and now laid her on her side of the floor by the bed. Not on the bed, but on the floor. So the EMTs get there. She's obviously suffered this massive head wound. They're attending to her, trying to save her life. There's absolutely no sign of life. She's obviously been dead for quite a period of time, but nevertheless, they make these Herculean efforts to try to save her. So, as it turns out, there's blood spatter attendant to that nightstand. Where did the blood come from? If it came from the bed, as the people suggested, his story is not believable. And in fact, the assault took place at the bed, and the assault continued down the hallway and eventually wound up in the bathroom. The defense theory was that they made these up as they went along. Number one was the blood spatter came from the EMTs, who were careless in the removal of their gloves. In other words, their gloves became slingshots and were spattering blood all over the room. Okay, that was number one. Number two was the defendant himself. While he was attending to his wife, he carelessly removed his shirt in haste, and some blood on that spattered out towards the nightstand. Okay, both of those stories are absurd on their face, but nevertheless, I'm not dealing with a jury that is in law enforcement or a jury who tries murder cases for a living. I'm dealing with lay people. So what Wynn was able to do, and just by happenstance, the officers at the scene were able to secure those 2 Poland Spring bottles. And if you picture them sitting in place by the nightstand, Wynn was able to show by 3D animation, moving a camera around, that the blood spatter had to have come from the bed. It would be physically impossible for it to have come from careless EMTs, and I'm sure they weren't careless. They said they removed their gloves like they were trained to do. They did it very, very properly. And this shirt, as far as the proof was concerned, was non-existent. That was devastating. And in addition to those 2 bottles, we also had a lampshade by Leslie's bed. The Wynn recreation of that, they showed a crime scene photo of the lampshade. They broke the lampshade itself down into 8 different sections, labeled them A, B, C, D, E, F, G, H. And they would show the jury, here's section A, here's section B, and here's section C. And the farther you got in terms of A, B, C, the more clear it was to the jury that the blood came from the bed. If the jury was convinced, as they were, that the blood came from the bed area, game over for the defendant. There's no other explanation for that. There's no innocent explanation for that. And the only explanation was, in fact, that the assault took place on the bed. And again, it's tough to describe in words how devastating that was to the defense. Well, when the defense came in with their, suggestion of how this crime occurred, their animation, the effect was not devastating, but the effect was substantial. People that I would screen it with and say, well, that, it looks reasonable. And it basically showed a animation of a woman slipping, falling in the shower, hitting her head. What it didn't show was the actual impact of the head. So what Wynn did was they took the defense animation, which shockingly was deceptive, and they created a 3D animation, not on their own, but of the defense data. And they showed that the angle of impact on the shower bench, which was the defense theory about how this poor woman died, was completely inconsistent with the autopsy photos. And they also did, some jurisdictions, New York included, you don't always get the autopsy photo into evidence because it's somewhat graphic. So what they did was they created animations of Leslie's head wounds, and they showed, the massive skull injury that she suffered, how it was completely inconsistent with the defense animation. And then on top of that, they did their own animation, which showed, based on all of the available evidence, all the autopsy photos, how it was much more likely that she suffered a blow to the head from some outside source other than the bench in the shower. It blew the defense out of the water. It was, and I talked to the jurors afterwards. They said, boy, after they didn't say Wynn because they didn't know that Wynn was involved in the case. They just thought Tom Larsen was, just a good guy working for me. But when they talked about the animation after the verdict, I said, after your presentation about what really happened, we didn't pay much attention to the defense animation at all. I don't want to give the impression that Wynn is a group of computer, CGI wizards. They may be that, but they're both also prosecutors or former prosecutors. Brian Carney, who is the owner of the company, who directs it, and it makes a huge difference because when I talk to Brian about the case, I save so much time because I don't have to explain to him the importance of the case. Then I've got Tom Larsen, who was embedded with me during the course of the trial, who is a former prosecutor from my hometown in New York City. And Tom, not only does he provide his technical expertise, but he also makes suggestions that I found extremely helpful throughout the course of the trial. Bill, let's present it this way. How about this for the jury? 9 times out of 9, he was spot on. That's the way, Tom, you're exactly right. That's the way to present it. And it just makes a difference. It's great that they have technical expertise, they understand computers, they understand video, but they also understand what a prosecutor has to do to convict somebody beyond a reasonable doubt. I started my first murder case in 1978, and I had testimony and pictures, and that was it. Maybe the first time I did a recreation, I did it myself. I, laid on a courtroom floor and tried to show a jury that the defense's theory was implausible. Then maybe the first time I ever used animation was I hired some artist that, $50 a sketch to show something, to a jury. Times have changed. Jurors are hip to CSI. They're hip to all kinds of crime shows, and we all suffer through that because we all know reality is different from television. But jurors, now they just don't want the testimony, the bland, not bland, but they don't want the testimony alone. They want to see it. And all kinds of studies that I've seen, when you tell somebody something and you show somebody something, their ability to comprehend that increases exponentially. And that's what Wynn is hip to. They get that. And, you might be worried about the cost. I certainly was worried about the cost in the Newlander case. I have available alternative sources of funding. Maybe you do too. But at some point, you've got to make a decision. How important is justice? You don't need Win for every case. You've got a clear-cut cause of death, and the issue is, was it self-defense or not? Then Win might be very important because they can recreate the crime scene. They can talk about trajectory analysis. They can talk about autopsy photos and recreating the scene, and so forth and so on. It's not for every case, but it certainly was for this case. And I can tell you more often than not, it is becoming an increasingly important for me, at least for me, to use this type of technology. But our job gets tougher and tougher every day. When you have verdicts that make no sense, when you have the verdict in the O.J. Simpson case, when you have a verdict like Casey Anthony, and juries say not guilty in those 2 cases despite the overwhelming amount of evidence, then you got to start thinking, am I really putting my best foot forward to present this case to a jury? And I understand we all have to live with budgets, and there are luxuries that we all can't afford. But trust me, if you hire Win, you're making a great move into putting your best case forward to make sure that justice is done. There ain't no price tag on that.
I've known Win Interactive and its work for 15 years or more since I first encountered the work done in the prosecution of Michael Skakel in Connecticut. At the time, that was absolutely cutting-edge visual technology. It was universally acknowledged to have been a major factor in the state securing a conviction of Mr. Skakel. And since that time, it seems that Win Interactive has not only kept up, it has pushed the envelope in terms of the development of new courtroom technologies. I think that Win Interactive does an extremely sophisticated job of being mindful of the lawyer's theory of the case and designing visuals, whatever they may be, to best serve that theory of the case. Sometimes it's pulling together video from different sources and arraying it so that the jury or the judge can see in an instant how that information fits together. That is, presenting the video in terms of a clear timeline of events. Sometimes it's juxtaposing video with animation to depict information that isn't exactly captured on the video but is represented by other evidence, so that the jurors can both see the other evidence unfolding in time and also see the video evidentiary basis for the evidence. The examples of visuals and multimedia that I've seen from Win Interactive over the years, I think do a tremendous job of fulfilling the lawyer's ethical responsibility to teach the facts of the case to the decision maker, as well as to assist the lawyer in persuading the audience. I think one of the reasons that Win Interactive is so effective is that it was founded by a practicing lawyer who was a DA for 11 years. And so Win Interactive knows the legal business and knows the business of legal advocacy from the inside out. They're not simply people who are good with tech, who come in from the outside to help lawyers who already have all the ideas realize their vision of the case. Win Interactive can bring a legally informed as well as a visually and technologically informed approach to whatever issue the lawyer may want to present. It's hard to predict where technology may go in the future, and it's hard to predict how courts will respond to new technologies. I expect that there will be more and more, for instance, video and work with video in courts simply because there's more video out there in the real world that becomes evidence. I expect that enterprising lawyers will also be continually introducing new forms of visual display into court. For instance, the visualizations of subjective experience, which I've seen in a handful of cases. I don't understand why it wouldn't be used in hundreds or thousands of cases. So more and more often, judges will be confronted with the decision of whether to admit and under what conditions to allow different forms of visuals in the courtroom. In addition, I think that considerations of both economy and security are going to be leading more legal proceedings to be moving from bricks and mortar courtroom to online environments where all interactions between all the parties are mediated by screens. right? So this is already happening in a limited extent in criminal proceedings, for instance, remote arraignments. It's happening to a greater extent in certain other countries. For instance, in Australia, expert witnesses frequently testify by video in ways that aren't done in the United States. But I think we're going in that direction. And what that means is that more lawyers will have to become more knowledgeable about the effects of presenting information on screens as opposed to in the traditional fashion. And again, developing the knowledge, the skill set, the vocabulary for understanding what's going on and being able to respond to the adversary's presentations.
Hi, I'm Brian Carney. For over 10 years, I was a prosecutor in the city of Boston. During my time there, I started the Interactive Multimedia Presentations Department, which still exists today. Upon leaving, I founded Win Interactive, and for the past 18 years, I've been helping prosecutors throughout the United States on high-profile criminal prosecutions present evidence using visualization technology, 3D animation, and interactive timelines. With my over 20 years experience in creating and presenting interactive timelines, we have developed CrimeLines, an interactive timeline tool for prosecutors. Timelines are easy to build, easy to present, and powerful. Prosecutors can now present complex evidence in a simple and organized way. With our 15 pre-designed templates, timelines can be colorful, clear, and professional without the need for a graphic designer or a trial consultant. All of your evidence, whether it's video, audio, documents, photographs, and diagrams, can be linked to any event. With CrimeLines groups and views, it's easy to create unique timelines for each witness using the same data set. CrimeLines is made by prosecutors for prosecutors. I'm proud to say that CrimeLines is now being used in over 25 states. Download your free copy or stop by our booth and learn how CrimeLines can help you achieve justice in your next trial.